The air in the federal district courtroom was so thick with tension, it felt like physical resistance against my lungs. I adjusted the lightweight, slightly oversized blazer I'd bought on sale, a conscious effort to appear professional rather than terrified. My heart hammered a staccato beat that completely drowned out the murmur of the crowd. Across the defendant's table sat my aunt, Celeste Sterling, and her two daughters, Madison and Chloe. They were a vision of expensive minimalism, white linen, enormous diamond studs, and expressions of icy entitlement. Aunt Celeste didn't even acknowledge me. She was whispering to her lead counsel, Mr. Desmond Hayes, a man notorious in Miami for his ability to bury small opponents in paperwork. He was built like a retired linebacker and carried himself with the heavy confidence of a man whose fees started at $800 an hour. They genuinely believed I was a nuisance, a forgotten relative whose single-room inheritance was worth infinitely less than the legal trouble I was causing them. They had offered me a check to drop the suit and walk away, confident that the $50,000 would look irresistible to a woman like me. Did they really think I would accept a bribe to abandon my grandfather's final wish? That I would sign away the one thing he believed in more than money? I placed my worn canvas satchel on the table. It contained 3 plastic folders, each tabbed with a different color: red, foundation, yellow, leverage, and blue, the truth. They had no idea what was hidden in the blue folder. The bailiff stood, his voice cutting through the noise. "All rise." Judge Herrera, a sharp-eyed woman with a reputation for merciless efficiency, took her seat. I took a deep breath. I was ready to dismantle the Sterling family's fiction. To understand the core of this conflict, you must know about my grandfather, Walter Sterling, and the extraordinary legacy he left behind. Grandpa Walter was the genius behind the Sterling Coastal Resort Group, building a chain of luxury hotels across the southeast coast. Aunt Celeste, his only surviving child, inherited the wealth, the company, and the social standing. I am Sloane Merritt. My mother was Walter's niece and a struggling marine biologist. After she passed away when I was 10, Grandpa Walter brought me in, not as a Sterling heir, but as an apprentice. While my cousins were learning polo and philanthropy, I was learning the ocean. Grandpa Walter was an avid, almost obsessive cartographer and conservationist. He saw the resort business as a necessary evil to fund his true passion: mapping and protecting the delicate coastal ecosystems. "They care about the property lines, Sloane," he used to tell me, pointing to his collection of antique maps. "You must care about the eco-lines, the lines that truly matter." He taught me meticulous data collection. Every tidal flow survey, every environmental impact report, every land use permit. "Keep the data safe," he'd insist, "because when money is involved, the facts are the first thing they try to drown. The proof must be stronger than their greed." I took those lessons to heart, working my way through the University of Miami on scholarships and becoming a licensed environmental consultant. I lived a life light years away from the Sterling compound, but I had his respect. When Grandpa Walter died a year and a half ago, the will reading was held at the Sterling Group headquarters, a skyscraper of glass and steel overlooking the very coast he loved. Aunt Celeste received the Sterling Coastal Resort Group, billions in assets, hotels, and controlling interests. Madison and Chloe received the substantial trusts and the family yacht. They were ecstatic. Then, the estate executor, a nervous-looking man, read my portion. "To my grandniece, Sloane Merritt," he announced, "I bequeath the entire portfolio of my private research acquisition trust, the Coastal Sentinel, and the ownership of the Walter Sterling Conservation Center." Aunt Celeste laughed, a brittle, dismissive sound. "A glorified nature center and a few dusty permits? That's his eccentric hobby fund." The executor adjusted his glasses. "Ma'am, the center is a 12-acre parcel of highly restricted land, strategically located on the last remaining undeveloped stretch of Barrier Island. Furthermore, the Coastal Sentinel Trust is endowed with sufficient liquid assets to maintain the center and its research in perpetuity. Based on the center's tax-exempt status and its development potential, if the conservation easements were ever removed, the value is listed as $8.9 million. The air went dead silent. The barrier island land. $8.9 million. The value wasn't just the land. It was the fact that the center blocked the Sterling Group from connecting two of their largest resorts, a crucial final piece of their development puzzle. That was the true inheritance. The barrier. The opening salvo was a masterclass in legal aggression. 3 weeks later, I was served with a lawsuit for breach of fiduciary duty and will contest. Aunt Celeste wasn't just contesting the will. She was claiming I was unfit to manage a significant piece of land. The petition was brutal. They alleged I was an unstable, fringe environmentalist whose plans for the land, pure conservation, were fiscally irresponsible and contrary to the Sterling Group's core mission. They argued Grandpa Walter was emotionally compromised when he wrote the will, having been indoctrinated by his grandniece's extremist views. Hayes, their lawyer, was a pit bull. He filed motions to freeze the center's research funds, immediately halting all fieldwork. The local press picked up the narrative instantly. Eco-terrorist relative blocks billion-dollar resort development. My consulting contracts dried up overnight. No one wanted to hire the woman publicly labeled an extremist who was suing a major Florida political donor. My attorney, a solo practitioner specializing in environmental law named Javier Morales, looked grim. "They are trying to crush you with litigation costs, Sloane. Hayes has filed 10 motions this week alone. We can't keep up." "What does he want?" I asked. "He wants the land," Morales said. "He wants you to sign over the center to the Sterling Group Foundation. They'll give you maybe $2 million cash and a non-disclosure agreement. It's the cost of doing business for them." I spent the next 2 days staring at the ceiling, thinking about giving in. $2 million would solve my financial problems for life, but it would destroy Grandpa Walter's legacy. Then I opened his most cherished possession, the old leather-bound map case. Tucked beneath his 18th century nautical charts was a single folded sheet of paper, the final codicil to the Sterling Trust, written 6 months before his death. I found the clause, written in his precise, beautiful hand: preservation and accountability. I read it 3 times. The terror was replaced by a cold, surgical calm. Any beneficiary or party directly benefiting from a beneficiary's action who initiates or substantially supports a legal or political action designed to revoke, impede, or materially alter the conservation or philanthropic purpose of another beneficiary's designated share shall immediately and irrevocably forfeit their entire interest in the Sterling Coastal Resort Group and the Sterling Trust, with all forfeited assets being transferred to the Coastal Sentinel Foundation. An absolute forfeiture clause. He hadn't just prepared me with data, he had installed a legal self-destruct mechanism to protect the center. If they sued to stop the center's conservation purpose, they would trigger the clause and lose the entire Sterling Group to the very foundation they hated. I called Morales immediately. "Javier, look at this. It's a poison pill." Morales arrived, read it, and whistled. "Sloane, this is nuclear. If the court finds their lawsuit's primary intent is to remove the conservation restriction and develop the land, which we know it is, they lose billions. The key is proving their intent isn't abstract, but financially motivated." We sent a final certified letter to Celeste and Hayes. It included the petition they filed and the unforgiving text of Article 8, Section D. The warning was clear: withdraw the lawsuit immediately or lose the Sterling Group. They didn't withdraw, they doubled down. Hayes filed an emergency motion to have the clause declared void for being unconscionable and financially punitive. They argued they were simply trying to ensure fiscal responsibility in the trust. My next step was to find the financial desperation that drove them. Grandpa Walter's lesson: the data doesn't lie. I dove into public records, development permits, and state lobbying disclosures. First, the Sterling Group. They had been aggressively lobbying the state legislature to pass an obscure amendment to the Coastal Development Act. I found the financial disclosure. The Sterling Group had invested $4.5 million in political contributions and lobbying fees to push this amendment. The amendment would allow them to bypass environmental review if they could prove they owned all contiguous coastal parcels. Second, Aunt Celeste. I searched the Sterling Group's recent filings. They had taken out an enormous bond, a debt backed by the company's future profits. The bond was callable in 90 days if the proposed Grand Reef Resort phase was not initiated. The penalty and cost of defaulting on the bond, $4.4 million. The final, terrifying piece of the puzzle. Lobbying investment, $4.5 million. Bond default, penalty, $4.4 million. Total cost of failure, $8.9 million. My inheritance. The exact precise value of the Coastal Sentinel Center. They weren't trying to manage the center. They were trying to eliminate it because it was the one piece of land preventing them from initiating the Grand Reef Resort project, defaulting on the $4.4 million bond, and rendering their $4.5 million lobbying investment utterly worthless. They were desperate, not responsible. I now had the smoking gun of their intent. Morales and I drafted the final counter-petition. Fraudulent intent in litigation and a motion for the immediate enforcement of the forfeiture clause. We attached the development bond, the lobbying records, and the internal Sterling Group environmental reports that contradicted their public claims. The final hearing was set in the federal district court. I stayed up all night, organizing the files. Red for the center's legal foundation, yellow for the Sterling Group's $8.9 million in exposed liabilities, and blue for the unforgiving forfeiture clause. When I looked in the mirror before dawn, I didn't see the woman they underestimated. I saw the daughter of a marine biologist and the heir to a cartographer's foresight. I pushed open the courtroom door. Celeste and her daughters, Madison and Chloe, were across the aisle, their faces drawn with suppressed anxiety. They knew their massive debt was now public knowledge. Hayes still looked confident, but his hands were shaking slightly as he rearranged his papers. I placed my satchel down. All rise. Judge Herrera looked at Hayes. Mr. Hayes, we have reviewed your motion to strike the forfeiture clause. We will address it after the respondent's evidence of motive. Hayes stood. Your Honor, this is a simple matter of fiscal responsibility. My client, the sole heir to this massive enterprise, is simply seeking to ensure that a $9 million asset is not wasted on the impractical whims of an inexperienced grandniece. When Judge Herrera called my name, I rose. Your Honor, the petitioner's claim of fiscal responsibility is a deliberate, malicious fabrication. This lawsuit is not about conservation, it is about desperation. The Sterling Group is exposed to exactly $8.9 million in imminent debt and failed investment that will materialize only if the Coastal Sentinel Center remains in conservation and prevents their resort expansion. I opened the yellow folder. I submit as Exhibit 1 the Sterling Group's bond agreement, which incurs a $4.4 million default penalty if the contiguous development is not initiated. I submit as Exhibit 2 lobbying expenditure disclosures totaling $4.5 million, rendered useless if the center remains a conservation area. I let the documents settle. Celeste and her daughters looked horrified. Hayes was stammering, unable to interrupt the presentation of pure, unassailable public data. The total exposure, Your Honor, is $8.9 million, the precise value of my inheritance. The primary purpose of this lawsuit is to legally dismantle the center's conservation status, thereby clearing the way for their development, saving them from financial ruin, and triggering the sale of the land. I then presented the blue folder. I now submit the final codicil, Article 8, Section D. This clause mandates forfeiture if legal action is taken to materially alter the conservation purpose of my share. The petitioner's action, demonstrably driven by a need to develop the land, is the very definition of that violation. Judge Herrera took her time, reading the bond agreement and the forfeiture clause side by side. She looked at Celeste. "Ms. Sterling, can you offer this court any justification for a lawsuit that, according to these records, appears to be an attempt to circumvent $8.9 million in corporate liabilities?" Celeste, utterly exposed, said nothing. Hayes tried one last time. "Your Honor, these are private corporate matters. They do not invalidate my client's right to challenge the will." "They establish motive, Mr. Hayes," the judge stated, her voice cold. "A powerful, self-serving motive that speaks directly to the bad faith required to trigger this clause." The gavel came down, sharp and unforgiving. The petition for will contest and breach of fiduciary duty is dismissed with prejudice. The court finds the action was initiated with the primary intent to alter the conservation purpose of the Coastal Sentinel Center. The court hereby enforces. The judge stared at Celeste. "Ms. Celeste Sterling, Madison Sterling and Chloe Sterling have immediately and irrevocably forfeited their entire interest in the Sterling Coastal Resort Group and the Sterling Trust. All assets are to be transferred to the Coastal Sentinel Foundation, effective immediately." I stood there, surrounded by the silence of their sudden, total ruin. I packed my folders. I didn't look at them as I walked out. The forfeiture was absolute. The entire Sterling Coastal Resort Group, hotels, assets, and capital, was transferred to the Coastal Sentinel Foundation. The foundation, now managing billions, immediately paid off the bond default, ceased all lobbying efforts, and used its new resources to turn the entire Sterling operation into a global leader in sustainable, eco-friendly luxury travel. I became the executive director of the foundation. Celeste and her daughters were left with only their personal possessions and their debts. I used a small fraction of the center's new liquid endowment to set up a scholarship fund for students pursuing sustainable development degrees. Aunt Celeste sent one final pleading email months later. "I hope you can forgive us. We made a mistake." I replied with only 2 sentences. "Grandpa Walter taught me that conservation is about setting boundaries. I have maintained them." No forgiveness. Justice had already been served. I look at Grandpa Walter's favorite map on my office wall every day. It's a 200-year-old charting of the coastal currents. He taught me that the most important lines are the ones you draw to protect what you value. I kept the data, and the data became my ultimate shield. So, here is my final question for you. Knowing that enforcing the forfeiture destroyed a multi-billion-dollar company but saved a vital coastal environment, would you have been able to sleep at night? Or would the weight of destroying your family's empire have been too heavy a price for justice? Drop your answer in the comments, and always, always keep the receipts. This is a fictionalized dramatization based on common themes in estate disputes. It is not legal or financial advice.